So today's topic, obviously, we're here for REMAX Advantage Plus. This is a presentation that I've put together specific for this group, specific for this brokerage, unique to you guys. So I've got some of my contact information. For those of you who don't already know me, I'm an attorney with the law firm of Fafinski, Mark & Johnson. My name is Brad Boyd. I've been practicing law for over a decade. Have been heavily focused in the real estate brokerage industry. I've had the unique opportunity to serve a lot of real estate brokerage companies and agents in compliance matters, a lot of transactional risk management issues, a lot of presentations throughout the state. I serve as the outside general counsel for the State Association of Realtors and work with a variety of local associations, brokerage companies, property management companies, and the like. So while my business is focused on corporate and real estate law, I have a fairly unique focus on real estate brokerage related issues specifically. So I try and bring some of my practical experience to a discussion like today. We're going to be first talking about what the TILA-RESPA Integrated Disclosure Rule is all about. So you saw the acronym TRID before. That's short for the TILA-RESPA Integrated Disclosure. And each TILA and RESPA are both acronyms again. So this is acronyms upon acronyms, but I think the upshot of it is this is the set of processes, the system in which the loan estimate and closing disclosure documentation is provided to clients of yours in the industry. We're going to talk about educating your clients about some of these changes in process, changes in disclosures and forms and timelines. Then we're going to talk a little bit about the increased significance of the CFPB, the Consumer Financial Protection Bureau, as they've shown what they're focused on through their regulatory actions. You'll remember that RESPA is a law that's been around since the 70s. The Real Estate Settlement Procedures Act, which bans referral fees and things of value in consideration for the expectation of or the receipt of a referral, that law has been federal law around since the 70s and enforced by HUD. The enforcement authority on that recently changed to the CFPB. And the CFPB has a very strong staff, a very strong budget, a very strong command on the legal issues, and they have been actively and vigorously pursuing enforcement of RESPA against title companies, mortgage companies, real estate brokerages, and the like. So we'll talk a little bit about why that's important and what that means to you. And then, of course, as I mentioned, I reserved a little time at the end that we can talk about some of your questions and get through some of those thoughts and topics as well. Brief promo for me. When you decide that you or your clients need to engage in counsel, definitely keep our firm, Fafinski, Mark & Johnson, in mind. Make sure that you and your clients know that it's a little bit like using a smoke detector instead of a firefighter in your transaction. What you want to do is be alert to issues as they arise, like a smoke detector is alert to smoke or a possible fire danger before it's gotten too far out of hand. You don't want to call the attorney to be the firefighter. Once it's all ashes and embers and we're just spraying it down with water, the result is going to be far less positive for you and your clients than if we can rush to the scene a little earlier in the process. Again, there's my contact information. We'll distribute this presentation after this seminar. So if some of you would like to share this with colleagues and friends of yours who weren't able to attend today, you're absolutely welcome to, or to review some of the notes and the resources I've got integrated into this. I want to say a brief thank you again to REMAX Advantage Plus, specifically Eric, Alicia, Sarah, and Krista. Everybody who helped put this together, I think, should be thanked and maybe applauded for a moment from you guys for getting this together. And thanks, of course, for allowing me to be part of it. I appreciate being here. So let's talk about this in a little more detail. This is a crash course in law, compliance, and best practices. We only want to take up about an hour of your time today, so we're not going to be able to exhaustively understand and explore each and every nuance of this law. The law itself runs over 1,000 pages in regulatory explanation. And so it's a little cumbersome, as you might imagine. If you're looking for some late night reading because you're having trouble sleeping, the new TRID documentation is an excellent place to start. But we're going to try and summarize some of the topics, give you a high level overview. Lenders and title companies really bear a lot of the weight and the pressure of some of these compliance-related issues. I think the title companies and lenders with whom I'm familiar who have been trying to get up to speed on it have put what I'd consider to be an exhaustive amount of time and energy into educating themselves, educating their clients, and getting their systems and processes together in a way that's going to fit what the regulations and the rules require of them. I think you'll find, and this is pure speculation on my part, but I wouldn't be the least bit surprised to see it come true. I think you'll find that some mortgage companies and some title companies simply won't be able to keep up anymore. I think some of the low-hanging fruit, the companies that are just getting by, are going to say, this is far too onerous and far too difficult. Changing over our systems, dealing with some of the best practices requirements out there, being fully up to speed on some of these new federal laws and guidelines just is too much to bear. And so you'll want to make sure that whether you're using the same title company or mortgage company you've used for years, or you have 2 or 3 or 4 of them that you draw upon regularly, you want to make sure that the companies you work with are up to speed on what this is all about. If you ask them, hey, how is your TRID compliance coming along? Do you guys feel pretty good about October 3rd? If they say, what's happening on October 3rd? You might be using the wrong company. So you want to actually kind of vet that out a little bit. The reason I say that that's an important thing is, although referrals cannot be given with the expectation of getting some value in return, that's a violation of federal law, as we all know, it's also obvious and fairly true that in the real estate marketplace, your clients and your consumers draw upon you as a knowledge center. There's a very good chance that you know good companies who operate title businesses or mortgage businesses to whom you think your clients might need or want to be referred. And maybe you give them a list of a few, just so you're not strong-arming them into this company or that company. But you want to make sure that your short list of providers in whom you have some faith and trust and confidence are actually going to be competent. And that becomes a much bigger deal as these October 3rd changes roll out. So it's a good opportunity for you, as we're just ahead of that timeline, to start having some conversations with a mortgage company or a title company, maybe several, just to get a sense of who's out there, who's ready, and what are they going to be doing for your clients to make sure that your clients are well protected. So we've got a few big picture topics that I'm going to talk about a little bit. As I mentioned, the first is understanding the TILA-RESPA Integrated Disclosure Rule, or TRID. Here's a snapshot overview. These are summary points, but I think the most important salient issues which you need to be familiar with. The first is that the good faith estimate and the HUD-1 have been replaced with a loan estimate and a closing disclosure. So you used to have this good faith estimate that had some of the details of what the consumer should expect when they get to closing. That is a document that has now been completely supplanted. That one's set aside. It's being replaced with a loan estimate. We used to have a document called the HUD-1 settlement statement. For a variety of reasons that are a bit too nuanced to get into in a 1-hour discussion, the HUD-1 settlement statement is still going to hang on. There are some exempt transactions to which this rule doesn't apply, and the HUD-1 settlement statement is the familiar and comfortable form for a lot of businesses, consumers, title companies, etc. So the HUD-1 settlement statement will still be there for some of the exempt transactions. A home equity line of credit transaction, certain transactions that fall outside of TRID will still see a HUD-1 settlement statement. The closing disclosure that we're going to be talking about is specifically a buyer-focused form. So depending on the preferences of the title companies you work with and the industry as a whole, I think Alta and various industry-focused organizations are going to suggest and have already suggested some best practices. You may still see the settlement statement or something akin to that being used on the seller side of the transaction. Because in any given transaction, we have two parties who are very important to the transaction, a buyer and a seller. And the buyer is typically the focus of all of these disclosures. The federal government is very concerned about the buyer understanding the loan terms, the closing costs, the fees that are associated with the transaction. But I think those of us who practice in the industry, those of us who have some real-world experience in dealing with these issues would say, I agree, the buyer is an extremely important part of this transaction, and transparency to them is exceedingly important. So too is the seller. And so too is the seller understanding the costs and the responsibilities they're going to assume within a transaction. So I mention this only because the terms you keep hearing as this change rolls out are loan estimate and closing disclosure. Many people, but not all, realize that the loan estimate is going to be the document that borrowers receive after the creditor has received 6 critical pieces of borrower information, which constitutes the loan application. 3 days after the loan application is received by the lender, 3 business days later, the consumer has to receive a loan estimate. Then 3 business days prior to closing, the borrower has to receive a closing disclosure. That's the document that most closely resembles what you're familiar with as a HUD-1 settlement statement. Basically a ledger, an accounting of costs, an explanation of fees and items that the borrower is paying for as part of the transaction. As mentioned, this rule becomes effective October 3rd, 2015. There's been a little bit of a stutter step here in the industry, as this was first supposed to roll out earlier in the summer. And the CFPB later said, you know what, there are some scenarios in our back office administration that need to have more time to mature and work their way through. And they also said the industry as a whole might need a delayed rollout just because of the timing of back to school. The summer time changeover would create a big ripple effect in the peak of the marketplace, so on and so forth. So as of October 3rd now, the rule becomes fully implemented. So there's been a good time to talk about it, but I think as many things happen within this industry and the business marketplace as a whole, sometimes it takes a little while for the word to trickle through on any major change in tide. So the penalties for violation is going to be what really keeps people focused on doing the right thing. The penalties can be pretty severe. If a creditor who's providing financing to a borrower violates these new TRID rules, the lowest possible violation is a $5,000 per day violation for every day in which they're out of compliance with the rules. It goes up steeply and aggressively if they have engaged in what I'd consider to be bad practices. If they had a reckless violation, they were careless, they were negligent, they weren't doing things right, weren't paying attention, the fee or penalty that they can be assessed ratchets up to $25,000 per day that they're out of compliance. So pretty considerable money for nearly any lender in the marketplace. If they're a really bad actor, then presumably they're not going to stick around very long, because the penalty for a violation that's a knowing violation. So this is the scenario where they knew they were doing wrong, they shouldn't have been doing wrong, and they did so anyway. $1 million per day for being out of compliance. What you will probably never see going forward, unless the lender or title company with whom you're working simply doesn't want to be in business anymore. What you will probably never see is a borrower and a seller who run into some new closing obstacles that are going to require a redisclosure, a new closing disclosure to come out. Bear in mind there are very few triggers, and we'll talk about them in a little bit. There are very few triggers that require a closing disclosure to be reissued. But the new practice is going to be that a consumer has to have this closing disclosure document in their hands 3 business days before closing. If a consumer gets it 2 business days before the scheduled closing, do you think the closing is likely to occur on the scheduled day? Yes or no? No. What happens if the lender or title company say, don't worry, I know this is very important. I know the borrower has family coming in from out of town. Their moving truck is already coordinated. They've already given notice on their apartment lease. They need this closing to occur. Has anybody ever heard something like that in connection with the closing? That tends to be a common conversation. That conversation may still occur in the future, but it won't yield the type of result that people are expecting for it. Because the reality is, if somebody says, let's just jam this closing through because we want to, and because the parties need it, that sounds to me a lot like a knowing violation of what the rules are and failing to adhere to them in terms of this 3-day requirement. So if penalties are on the line of $1 million for such a violation, I'm going to venture a guess that many mortgage companies and title companies are not going to be comfortable just closing because the parties want them to. What we'll likely find is an extraordinary focus on compliance. The real estate marketplace, particularly in residential real estate, tends to be a fairly cooperative industry. I think relationships among business enterprises, relationships with consumers, even relationships between technically adverse parties. In a residential real estate sale transaction, the seller and the buyer are conceptually at least adverse parties. They may each want the property to be sold or acquired, but they have different goals and expectations for how that might come together. Even the adverse parties tend to be cooperative. So it's generally an industry in which a super hyper focus on compliance isn't always the norm. Obviously, people are following the rules, they want to follow the law, they want to understand the obligations, but we've certainly seen transactions in the past before such a strong rule was in place where somebody said, hey, we ran into some last minute glitches, let's just put this all together and get it done. Now there's a rule that says, depending on what these circumstances are, if there's a required redisclosure or you didn't get your 3-day lead time before closing, we're simply not going to be able to close on time. What's the single biggest issue that I see that causing a little bit of a tension with? What we refer to as stacked closings, or the domino effect closings, right? It's pretty common in Minnesota, and this isn't common in every state in the country, but it's pretty common in Minnesota that if I'm selling a home and I'm going to purchase another home, I may set the closings up for both of those transactions on the same day. Ideally, in a perfect world, I would sell my home at 11 a.m. and I might purchase the next home with a 1 p.m. closing. The hours can vary, of course. But the idea would be I'm going to take the proceeds, to the extent there are any, out of the sale of my house, and I'm going to drop those in, plus possibly some mortgage financing, into the purchase of another home. If for any reason, any of the impacted transactions, my sale, my purchase, a later purchase from that seller, if any of those transactions require a redisclosure or the timelines weren't strictly met, guess what's not going to happen? Perfectly orchestrated and perfectly synchronized closings. I don't want to strike paranoia into people. I hear a lot of folks out there saying, there's too much fear factor about what happens to disrupted closings. Let's not worry about it. Let's just see how it plays out. Maybe this is all just hype for no good reason. So I'll be a partial optimist. That's a real strain for me. I'll pretend that I'm a partial optimist and that I'm buying into the theory that maybe it's not as bad as some folks in the industry are conjecturing. If that's true, please go about your business exactly as you're doing today and schedule stacked closings and set your client expectations such that you're telling them closing will absolutely occur on time, it couldn't be otherwise, and there won't possibly be a glitch. Or, if you're a little more pragmatic, you may say, we are absolutely hopeful and we sincerely believe that closing could occur on the scheduled closing date. But there are some events and some circumstances that are outside of our control, and if for some reason the closing can't occur on the scheduled closing date, we're all going to have to communicate. We're all going to have to be as cooperative as we can, and we're all have to try and figure out how we adapt to the new circumstances. The one thing that I do know for certain is we cannot predict how this will all occur. Lots of people are trying. Lots of people are making some very strong, educated guesses. But from this October 3rd timeline rolling forward, I think we'll see a lot of new things. And I think we'll get a better impression of how this is all going to get integrated into the marketplace once we actually get there. So we want to be prepared, but I don't think anybody should be thinking that they can predict the future with great accuracy at this point. So let's talk about those documents just a bit more. The loan estimate, as I mentioned, is a document that's provided by the creditor or lender. It's got to be given within 3 days, 3 business days of the receipt of a loan application. This loan estimate gets resent in certain circumstances. So for those of you who are dealing with buyers on occasion, you want to make sure that the buyer understands that they're going to receive a loan estimate, which they should carefully review, and they should make sure that the right fees and issues are addressed. Once they have looked at that loan estimate, they might see it coming again. So it might get resent in the scenarios you see in front of you. First, if there is inaccurate information provided by the consumer. If the lender learns that the borrower didn't identify the real place they work at, or their appropriate income, or some of their debts, or whatever the information was that was provided inaccurately, once that new information is known to the lender, they're going to have to reissue a loan estimate. Same thing if there's an extraordinary event. It's not particularly well defined, but let's presume it's something different than what you see in every transaction. The third is discovery of new information related to the consumer transaction, which would significantly alter the terms. The fourth is a revision requested by the consumer. If the consumer sees some sort of problem in the loan estimate, at their request, they're asking for a change, a new loan estimate will be sent out. The 5th is the day of rate lock. So when the consumer finally says, I want to lock in my interest rate at this point, a loan estimate's going to go out again. And then the 6th and final one is after the 10-day expiration period. There's a 10-day window. There's lots of timelines that are important within this subject, but there's a 10-day timeline where the clock starts ticking from the time the lender has received all of the information necessary from the consumer to constitute a loan application. Once they've had that loan application information in their hands, a 10-day clock starts ticking. And within that 10 days, the consumer has to say, I'm on board, I'm moving forward with the transaction. They have to affirmatively confirm to the lender that they're moving forward. At that point, everything proceeds as normal. If they don't affirmatively confirm that they're proceeding with the transaction, then it kind of goes dormant. And if they start to reinitiate the process, then they're going to receive another new loan estimate from the lender. So a document that is intended to simplify the understanding of the borrower's financial details of the transaction will hopefully, in fact, do that. It will hopefully accomplish its purpose. But what might be confusing to consumers as this rolls out is they might see this loan estimate on multiple occasions. You, as the agents representing some of these consumers, might be well positioned to say, listen, buyer, as you're going through this transaction, I just want you to know there's some new information that might be different than how you've seen these transactions work in the past, if in fact you've purchased a home before. If you've purchased a home before and you had a loan application that was done and you received some information about that loan early on in the process and everything seemed a little loosey-goosey with the timelines, bear in mind that's very different now. Now, within 3 business days of getting a loan application to the lender, you're going to receive what's called a loan estimate. You want to review it very carefully and make sure the numbers make sense to you. Ask any questions you have of your lender. And you might see that document come again. If you see the document come again, what's that mean? Something's changed. They didn't just forget they sent it to you before. There's been some sort of change to the document, or 10 days have elapsed and you didn't affirmatively indicate you're proceeding with a transaction. So you want to prepare your clients for some of these things. Communication becomes increasingly important in a technology-driven marketplace. It's always been a vital role of the real estate agent to be the great communicator among the parties and businesses involved in a transaction, even more so now. Even more so because you're the client's point of contact on a great many issues, and they need to have some understanding of what's coming. So the closing disclosure, that's the last document in the sequence of the transaction. And the closing disclosure is basically the ledger, the accounting, the financial information of the final details of the transaction as applied to the borrower. So as I mentioned, this replaces the HUD-1 settlement statement. The closing disclosure must also be provided to the consumer 3 business days prior to closing. Business days is defined very uniquely within this act in various places. Here, it's all days except Sunday and federal holidays are business days. So when we're talking about a closing disclosure, the term business days has an absolute and finite meaning. It's different when we're talking about the loan estimate, and I'll read it for accuracy. When we're talking about the loan estimate, a business day is defined as a day on which the creditor's offices are open to the public for carrying out substantially all of its business functions. Note, each lender may define their business days differently. How's that for simplicity? The good news for you is it's up to the lender to understand what their business days are and to comply with it. And the burden is really on them in terms of penalties. So although that's a little bit of a flexible timetable, may or may not include Saturdays. If the lender's office closes on Friday because they've all gone fishing, that may not be a business day. It's a little bit tough to judge exactly what the timeline is, but I think any of us can count up to 3 pretty easily and say, I'm guessing it's going to be about within this window. Let's exclude Sundays, let's exclude federal holidays. Maybe the lender's got an extra day or 2 in there for a closed office for some reason we're not aware of. But the loan estimate is going to be a little harder to predict in terms of timing sequence. Closing disclosure should not be hard to predict. closing disclosure has a very definitive timeline. 3 business days means all days except Sundays and federal holidays. Let's educate our clients about what this process is all about. It's great that you're here. I applaud you for being here. It's important to be engaged in what's going on in your business. And it's wise for all of you to be at a place where your competitors and some of your colleagues aren't learning about the things that they may not already know. The next step, I think, is that we need to educate the consuming public and clients of yours, particularly on the borrower side, because they're going to be the most directly impacted by the new set of rules. Specific timelines now are incredibly important. They've got to be followed properly or the transaction will not close. Although not all of that lies on your shoulders, I think the best agents in the industry will be differentiating themselves by knowing some of these timelines, committing them to a calendar, perhaps providing a snapshot to their clients, getting the word out so the clients have some expectation of what's happening. Worst case scenario is a client's closing gets delayed because something didn't happen in the scheduled timeline. And the client says, I never knew this could have happened. Why didn't you tell me how important these timelines were? Easy problem to fix. We can get out ahead of that bus. We just have to be spreading the word, getting some of the information out to the right people at the right time. There is a document called a Small Entity Compliance Guide. Unfortunately, it's not a short document, or I would share more details with you in this short discussion that we have today. It's a very comprehensive guide. It is very helpful. The fact that it's long is reflective of the fact that a lot of detail and attention and thought went into it. It's put together by the Consumer Financial Protection Bureau. The screenshot you see here, the green and white, is what you'll see when you go to the website. It's a PDF file, many pages long, but extremely helpful and extremely comprehensive in what it provides. I've got a link here. As I mentioned, we'll send out the presentation link to those of you who are interested. And if you click on this hyperlink, it will go right to the resource that I'm mentioning. This Small Entity Compliance Guide is really designed to be business-oriented. There are different guides and frequently asked questions available to consumers. If you go to consumerfinance.gov or do a Google or Bing search, use your favorite search engine, and look for Consumer Financial Protection Bureau, or TRID, you will get the information relevant to this new TRID integrated disclosures. Next main topic is recognizing the impact of the increased RESPA compliance and enforcement procedures and the role of the CFPB. The CFPB is doing their job. They're a Consumer Financial Protection Bureau. What does that mean? They're focused on things that harm consumers, and they're focused on bringing those issues and problems to a halt. It's a bit like what you know the Department of Commerce to be engaged in Minnesota, but on a federal scale. The value proposition, so to speak, of the CFPB is they have a strong budget and strong staffing and a good eye for compliance-related issues. The downside for businesses is no business is perfect. Not everybody is going to do everything exactly right all the time. And so if the CFPB looks into your business practice long enough and hard enough, there's a pretty good chance they might be able to find something amiss for nearly anyone. Your goal and the expectations placed on you is you understand the law and you will comply with the law. And if the CFPB looks, they will find nothing amiss. It's a fairly high bar, but one I think we need to be particularly attentive to trying to follow, particularly as they show how serious they are about RESPA enforcement. The CFPB manages all sorts of regulatory issues, from Fair Debt Collection Practices Act, the Fair Credit Reporting Act, to RESPA, on and on and on. So it's not like they've got all their attention focused on RESPA compliance, but they've certainly made a splash in that arena, and they are certainly indicating that they have a lot of focus and attention to devote to that issue. Let me go back one step here. You'll see in front of you this newsroom link, enforcement actions and the CFPB updates. I would encourage you to take a look at it. Just like I encourage people in any risk management class to look at Minnesota Department of Commerce enforcement actions. Why? Because you need to know what the laws are, you need to know what the rules are. You can try and read and learn every law and rule out there, and I'd encourage you to go on that expedition, but you're not going to figure it out all overnight. What you can get a pretty good snapshot on is the issues that are triggering problems for others in the industry. You can do that by looking at Minnesota Department of Commerce enforcement actions to see what the state regulator doesn't like and wants to see you clean up. And you can do that on the federal side by looking at the CFPB website. They make it easy for you by having a tab called Newsroom. And the Newsroom has a bunch of stuff that talks about what they're up to, including their enforcement actions. How do they get your attention? By penalizing businesses to the tune of hundreds of thousands of dollars and millions of dollars. If that doesn't get attention of businesses in the industry, what else will? The reality is they take violations of RESPA and related laws that are under their umbrella quite seriously, and they're very aggressive in their approach. And again, it's all in the name of protecting the consuming public, but of course the hurt can feel pretty heavy on some of the businesses they've investigated. So noteworthy CFPB decisions within this industry are recently, in the last year, Lighthouse Title. Lighthouse Title was a title company that was investigated by the CFPB and ultimately found in a violation or signed a consent order for having an improperly structured MSA and impermissible referral fees. So the idea, in kind of layman's terms, is they were too cozy with others outside of the title industry who were other settlement service providers. Be it mortgage companies, real estate brokerage companies, the relationships were too tight and there was too much either money exchanging hands or the expectation of money exchanging hands, particularly pursuant to an MSA, a marketing service agreement that the CFPB found to be problematic. That carried with it a $200,000 penalty for Lighthouse Title. How many of you have friends, not you of course, because we don't want to bring any pressure on you, how many of you have friends who you believe might have entered MSAs, marketing service agreements, with lenders or title companies in the marketplace? Raise your hand if you've heard of something like that, a marketing service agreement entered by a friend. Not you, by a friend, right? So these are out there. Marketing service agreements are generally agreements that identify that two companies are going to collaboratively market in some capacity. Marketing service agreements are not illegal out of the chutes. Marketing service agreements have the possibility of being legal and proper and permissible, but they have to be structured exceedingly carefully. And the reality is, just because they're legal doesn't mean everybody wants to do them and use them in the way that is most compliant, best practices, and the way to do it legally. People have gotten sloppy with marketing service agreements. It's unfortunate because it's costing some people $200,000. You want to make sure that if you or your friends, anybody you know, has ever uttered the term marketing services agreement, or you have some sort of agreement, whether oral or written, with another settlement service provider in which you're going to jointly market, share a billboard, share a direct mail ad, place them on your website, you get placed on their website, any sort of relationships like that where there's co-marketing going on needs to be done right. And if it's not done right, it's a violation of RESPA. And the reality is, most people don't want to put the time and energy and cost that's necessary to doing it right. I've had countless people, clients, prospective clients, people who've said, hey Brad, I want to do a MSA, I want to get it right. I've got about an hour's worth of legal fees to spend on this project. Can we get this done? Well, what's the answer? No. It's kind of like saying, I want an architectural plan to build the perfect house, but I don't want it to take any time or energy. I just want it to appear out of the ether. Good luck. Some of these roads are challenging. And when we're talking about RESPA compliance, it's not a flip a switch, yes or no answer. It's a intensive, thoughtful, considered approach, and you have to be very measured in what you're doing with regard to affiliated business arrangements, MSAs, etc. So Lighthouse Title, $200,000 penalty for an improper MSA, according to CFPB. Realty South, JRHBW Realty, they just received, or not just, but in the last 6 to 9 months, a penalty in the amount of $500,000. Pretty high magnitude penalty. Doled out by the CFPB for what? For an improper affiliated business arrangement disclosure. If you read that consent order, which I have, it identifies that Realty South had affiliated business arrangements, as many, many, many title companies, mortgage companies, and real estate brokerages have, And according to the CFPB's analysis, their affiliated business arrangement was not compliant, in that the disclosure promoted or sold the company receiving the referral too heavily. Instead of being strictly compliant with what the model expectation is on purely identifying the type of relationship, identifying that consumers have the right to shop around, identifying the scope and range of fees that the service provider might charge, according to CFPB, they went too far, and it was too promotional of the company being referred. So that and some other issues tied into that resulted in a $500,000 penalty. So all of this stuff is very serious emphasis for the marketplace, in that the old guard is gone. HUD is no longer monitoring and managing RESPA compliance. It's now the new sheriff in town, it's the CFPB. They're the ones saying, we decide whether you're in compliance or not. And for a lot of people they've investigated so far, they're determining you're not in compliance. And when they've made those determinations, the penalties tend to be significant. Similarly, if you say, well, this is all just federal stuff, I don't really think I'm engaged in anything that could be a RESPA violation. I don't think the CFPB has any time to focus on me. I'm just a small fish in a big pond. Well, Minnesota Department of Commerce tends to take a pretty active look at the licensees within the state of Minnesota. They have new enforcement actions monthly at least, and sometimes weekly or more regularly. And they recently entered a consent order that's publicly available. It's published on their website with TitleSmart. They identify that TitleSmart engaged in RESPA violations by having a special unique boat cruise event, which had invitees who were primarily and almost exclusively settlement service providers. So real estate agents, mortgage companies with whom TitleSmart was shown to have done business were invited on a pretty nice boat cruise. Sounded like it was a well-appointed, nice event for folks. But unfortunately, this providing a thing of value in connection with a referral or the expectation of receiving a referral is just out and out a violation of federal law. There's no workaround for it. There's no watered down test where you say, well, I got a referral and all I gave was a $20 coffee card. Is that a violation? Yes. If you send business to a mortgage company and they send you a $20 gift card and you're a settlement service provider, both of you have violated RESPA. If you send business to a title company or a mortgage company and they send you on a trip or they invite you to a specialty cruise just for folks who have sent them business, anything like that, that's a RESPA violation. And it should be pretty clear from the signs in the marketplace that the eyes are everywhere. Between the CFPB and the Department of Commerce, it's not like this stuff's all going to fly under the radar and nobody's ever going to be wiser. The reality is people are looking for violations. They want to find those folks who are doing it wrong for the benefit of the consuming marketplace. So you do have to be extremely careful about doing your job. Doing your job as a real estate agent well. Making sure that if you refer somebody to a title company, a mortgage company, whomever, you're doing it because they're good at their job. You hope people refer business to you because you're good at your job. You don't want anything beyond that. If the idea is I want a real good, real cozy relationship, and I want that company to refer business to me, and I'm going to refer business to that company, we're looking at this all wrong. RESPA compliance can be so simple if all you're focused on is doing your job well and being around other businesses and service providers who like doing their job well. That's basically, at the end of the day, that's RESPA Compliance 101. Don't have an expectation that somebody's going to send you business because of something you did for them. That's RESPA 101. It all boils down to a pretty simple equation. Do what you do well, work with others who do what they do well, have no expectations or money or value consideration beyond that. So what's the warning? The warning is the CFPB may, and in fact is, enforcing RESPA more vigorously than HUD did. Some people just grew comfortable with the RESPA violations they had because they said it's a bit akin to speeding, 73 miles an hour in a 70-mile-an-hour zone. I know I'm violating the law, but I haven't seen anybody have real problems with it quite yet. Well, unfortunately, the enforcement actions we're seeing out of the CFPB and the Department of Commerce, I would say are a bit akin to seeing a police or highway patrol regularly picking up people who are just over the speed limit. and really sticking it to the people who are heavily speeding. RESPA enforcement is real, it's significant, you've got to be careful about it. Don't worry about whether you're just barely speeding or speeding a lot. Either way, you're going to have to stop it. And if you're speeding a lot, in the RESPA terms, I'd be particularly concerned and fix those practices as soon as possible. One note I've made here is don't assume your practices are okay because others are doing it. When I'm advising a client who's got questions about RESPA violations or how to do things right in the world of RESPA, the scenario and the phrasing that I hear from people most often is, well, this guy's doing it, or that company's doing it, how come I can't? Why are you raining on my parade? Why are you making it difficult for me? Because I want to do it, and if I don't do it, my competitors will, and I need to keep the competitive edge. Let me let you in on a little secret. Keeping the competitive edge means staying in business. If the competitive edge requires you to do things that are violating federal law, you won't have the competitive edge for long. Best practices is keep your nose clean, stay in business, and therein is the competitive edge. Also, don't say that because I heard at one point from somebody, or I shared a 10-minute conversation with an attorney about my business model, I'm now compliant. He or she blessed it, and I never have anything to worry about. It doesn't ever happen. I don't know of any attorneys in the marketplace who say, your business is completely compliant. You have done nothing wrong, and I can't imagine you ever will do anything wrong. Don't worry about a thing. Most attorneys are realists. Some might say cynics. But most attorneys would say, when asked, I would encourage you to do X, Y, and Z. Here are some good practices. I would encourage you to stay away from A, B, and C. These are some bad practices. As long as you can follow some of these directions and do 100 other things right, the risk is managed. But remember, RESPA is largely a risk management issue, not a we can guarantee that you will not ever violate the law sort of an issue. So when in doubt, of course, seek counsel. The law. What's the law on these issues? Well, we already talked about it. RESPA prohibits referral fees. The law hasn't changed in decades. The RESPA law regarding referral fees has not changed since the 70s. What's important is that the enforcement has become more vigorous. The relationships are being focused in on with more eye for detail than they perhaps were in the past. And as I mentioned, MSAs and affiliated business arrangements appear to be particularly at risk. So I'd give serious thought to examining those if you're involved in those. What are the timelines we've been talking about today? The loan estimate, remember, is the main document after the loan application is obtained by the creditor. The loan estimate has to be provided within 3 business days after application. And again, this is that unique definition of business days. It's the days in which the creditors or offices are open to the public for substantially all of its business. The closing disclosure, the final document that replaces the HUD-1 settlement statement for a borrower, that document has to be provided no less than 3 business days before consummation. Consummation is a funny new term for the time in which the borrower becomes obligated on the loan. So you could effectively have a closing when the transaction, as you're familiar with it, occurs, and the consummation could have actually occurred a day earlier or a day later, depending on when the borrower signed up for all the loan documents that commits them to the loan. That closing disclosure has to be in their hands 3 business days before closing, or it will not close on time. Most lenders, I suspect, are going to be very proactive about this. There are some rules on whether it's mailed, whether it's couriered, whether it's hand-delivered, whether it's sent by email, but basically the lender has to verify that it's in their hands 3 business days before closing. Or if mailed, they have to have another 3-day lead time. So I think we'll see a lot of stuff that's going to be couriered, emailed, hand-delivered, etc. October 3rd, 2015. This is rolling out really quick. It's great timing for you guys to be aware of it as it's approaching. It's an important timeline for you to encourage your clients and educate your clients about what the process is going to look like. So the main things to look for are a new loan estimate, a new closing disclosure as this all rolls forward, and a new set of timelines applicable to both of those. Some resources and references. I won't go through this in great detail right now, but if you look at the presentation after today's discussion, you're welcome to click on these links. The National Association of Realtors uses as its RESPA Council a gentleman by the name of Phil Schulman with K&L Gates. I've seen him speak several times, a very bright very educated, very capable attorney who understands RESPA with an exacting detail that most practitioners throughout the nation don't have a similar level of understanding on. He put together a very comprehensive PowerPoint that explains some of these changes in great detail. It's available publicly at this PDF. Similarly, the National Association of Realtors has a senior counsel on staff by the name of Finley Maxon. He put together a short YouTube video overview of the TRID changes. That's available through the link I've got on the screen for you. And then finally, the Consumer Financial Protection Bureau has their TILA-RESPA Integrated Disclosure Rule page. So within the CFPB website that covers an array of different topics and categories and substantive areas, they've put together a page specific for the TRID new rules. And they've got frequently asked questions, they've got some handout sheets, great deal of information that you can look into if you're trying to find out more information about this subject. Let's talk through a couple quick practical considerations. First, the revised closing disclosure. I mentioned there are times where the closing disclosure is going to have to be provided again, resetting that 3-day clock before closing can occur. The changes that require redisclosure of the closing disclosure are as you see in front of you. One is a change in APR of more than 1/8 of 1% in what they call a regular transaction, and that's got a defined explanation, or more than 1/4 of 1% change in an irregular transaction. The simple way that people are referring to this is regular transaction is a fixed rate loan and an irregular transaction is an adjustable rate loan product. That's not precisely true because there are other variances in those two definitions, but as a general way of looking at it, it's the lender who's got to be fully versed in what this means. From your vantage point, that may be an appropriate way to look at it, big picture. The change in the loan product will also trigger a redisclosure. So if the consumer decides that they're going to go from an adjustable rate mortgage product to a fixed rate mortgage product or the reverse, in either of those scenarios, there's going to be a redisclosure of the closing disclosure, resetting the 3-day lead time before closing. And then the final one is the addition of a prepayment penalty. You do not see within here any comment or reference to the parties have some sort of financial concession that came up last minute. So if you do a walkthrough and there's got to be another $500 contribution from the seller to fix something that's broken, that doesn't technically require a new closing disclosure and a new 3-day clock being reset. What it does require is the updated closing disclosure verified by the lender. That may take some time. That may not be an immediate process. What we're familiar with happening at the closing table in real time, can we quick make a change here? Can we quick make a change there? Don't get upset with the title company or the closers if they say this has to go back up the chain of command to the lender. The lender has to sign off on it. It's what they're supposed to do. That's what the lenders are supposed to do. Hopefully, some of the lenders out there, the best in the business, will have a quick rapid response program to address those sorts of issues. What rapid response means probably is going to vary immensely from business to business. So be aware of the fact that timelines are incredibly important to all these disclosure-related issues. Then my kind of anecdotal comment here is to avoid delays or frustrations, consumers and you, their agents, should be looking for the disclosures, should review the disclosures and documentations, and ask any questions that you or your clients have about them. Don't just sit in the dark and wait until closing and say, oh yes, we'd now like to better understand what this closing disclosure says. That's been happening a lot with the HUD-1 settlement statement. Somebody might not even look at it until closing. Then they expect their closer to go through it in a 2 or 3 hour review session in exacting detail. Those days are gone. It is the consumer's responsibility and the professionals in the transaction to help them understand long before we get to closing so we can resolve those questions. Here are some reminders and takeaways, and then I want to take a few minutes of your questions. 5 key points to try and remember. 1, be wary of MSAs, referral relationships, and any other issues that might be high risk as we've discussed them for RESPA violations. 2nd, check in with title companies and mortgage companies. If you're going to refer somebody or suggest that somebody is a competent and reliable resource, make sure you understand that they're relatively conversant and comfortable with some of these changes we've been talking about. Confirm their readiness for the TRID implementation and ask them if they anticipate more lead time needed for closing. Some of the companies I've talked to have said, we don't want to see 30-day closing windows. It's going to be too tight. Maybe we'll get there once everybody understands how this works. But let's have 45 to 60-day closing windows, so we at least have a little rollout time. I'm not in charge of that. Your client's not in charge of that. They have a voice in it, but you need to make sure that the professionals in whom they're relying have the ability to meet those timelines before you set a timeline that simply is unrealistic. Be sure that any fees you are charging in the transaction are known to your client and the lender for an accurate estimate. Make sure that if there are fees you're aware of that the lender might be conjecturing about, you can help explain to them the specifics so they get the loan estimate right. Get familiar with the forms yourself. They're all available at the CFPB website. You can look at them. This doesn't have to be a surprise the first transaction you go through. You can actually ready yourself and be aware of it so you can explain some of the answers to your clients. And then finally, realize that last-minute changes are now going to be more complicated. Like I said, it's not going to necessarily require a new 3-day waiting period, but it may require and will require the lender's approval and may take some amount of time for them to do that. A lot of information in a short time period. I appreciate you bearing with me and reserving your questions. Are there a few questions that I can answer for you? Go ahead. It's a great question. I appreciate you raising it. So I wasn't particularly clear on that. October 3rd is the rollout for loan applications taken on or after October 3rd. So if you've got a deal pending right now with an executed purchase agreement, a loan application that's already been taken by the lender, that transaction will not be impacted. That will not be disrupted or changed. It'll be for the loan applications taken on or after October 3rd.
Thank you.
You're welcome. Any other questions? Yes. That is a wonderful question. Just as I recall, we were taking a video. Let me repeat the question just for the benefit of the video as well. Great question was, are there repercussions for us as real estate agents if we're representing the seller side of the transaction? As we discussed, the rule focuses largely on borrowers, but what happens if because of the borrower or the lender and some timeline delay there, now the seller's apple cart is upset. The seller can't close on time. It's a complicated question to answer, and let me explain why. The ramifications on you are going to be minimal to non-existent as long as your seller client is understanding and familiar with what could occur. And that's why I suggested earlier, communication is so vital to this process. And if I were in your shoes as agents, I'd want my borrower side client or my seller side client to very clearly understand that the closing date is a real date, and it's one in which every party is expected to do their due diligence and best practices to meet it. And if somebody doesn't close on the closing date, it's technically a breach of contract. Unless you've built in a contingency for that circumstance, if the buyer doesn't show up when the buyer's scheduled to close, even if it's some fault of the lender just didn't have their ducks in a row, the buyer is still in breach of contract. And so there are various remedies, and that will be in our second and third hours today for those of you who are staying along. That's just a joke. Separate topic entirely, but the remedies for breach of contract include statutory cancellation, voluntary cancellation, going to court to get a declaratory cancellation, suing for damages or expecting specific performances, the remedy of a lawsuit. There are all sorts of scenarios that open up once Pandora's box has been initiated, and that's somebody doesn't show up at closing, somebody's in breach of the purchase agreement. The seller is certainly going to be unhappy with a buyer who doesn't close on time. Whether that's going to harm you is fully dependent on how well did you inform the seller that this could occur. And I'd say as long as you were transparent and thoughtful and proactive with the seller and you explain there's some new rules, it's possible that a borrower's closing gets delayed partially outside of their control or possibly because they didn't do something on time. I think sellers really need to know that closing is supposed to happen on the day it's scheduled, and there's some contractual obligations there, but we also have to be prepared for the what-if scenarios. Yes?
It's difficult to keep a buyer's earnest money. Would that be correct?
Apt, yeah, and I'll repeat the question again for the video. The question was, would it be wise to have within a financing contingency that written statement requirement so that a borrower actually has to have a little bit higher level of commitment from the lender that the financing is on board in advance of closing? And I say absolutely. Great point. I think in the scenarios moving forward for the protection of your sellers, that's exactly what you want to do. You want to make sure that any financing contingency that's entered has the second option in the conventional financing addendum as we know it, that says you have to provide a written statement suggesting that the appraisal's done and all the requirements by the lender are complete, subject to whatever conditions they have. From that point forward, once the written statement is delivered to the seller, then as you point out, the earnest money is the hook that keeps the buyer engaged in the transaction. It doesn't mean that if the buyer doesn't close on the scheduled closing date, the seller will automatically get their earnest money. But it at least gives a bit of leverage, and that'll play out depending on whether they cancel or change the closing date, et cetera. Be prepared, and the kind of second level of that discussion is the other piece that would be important is to be ready and prepared to consider how and when you're going to amend a purchase agreement if closing doesn't occur on time. What I think we'll see more of, or what I would suggest we might see more of, because I think this is wise for sellers, is that if the buyer defaults on the conditions of the purchase agreement and it's changed something and put in this domino effect for the seller and has incurred cost to them, it's fully within the seller's rights to say, listen, I didn't cause this train wreck. And buyer, if you need another week or 2 days or 5 days or 10 days to have a rescheduled closing, we're going to ask you for some sort of concession. You didn't meet the original closing date and the terms we agreed upon. If you want to change date, I'm willing to amend the purchase agreement, but we need some sort of financial concession. Maybe just covering the seller's actual costs. Maybe they have some moving costs and some rate lock on their next transaction that are impacted. And it won't be easy to come by. Buyers are generally not going to like that idea, particularly if the buyer's lender caused the problem. But here's the linkage that ties everything together. Buyers, sellers, agents, title companies, mortgage companies all have to do their job right. They have to be very sensitive to timelines, have to make sure all the information is in the hopper at the right point in time. Yes?
Could you add that verbiage in both dates in this?
I'd say you can do that with the advice of the parties' counsel. It's difficult to craft that language in a way that's going to suit all transactions and all parties. As we know, every term of a purchase agreement is negotiable, and depending on how you craft that language, the buyer is very likely to say, this is completely objectionable and I want no part of it, or the seller may say, this isn't strong enough for me. So I think you have to analyze that sort of additional provision in real time based on the needs and the goals of the parties and what can everybody agree to. So it is, and I don't want to sound self-promoting, but far too regularly people get by in a residential real estate transaction without ever talking to an attorney, and they believe there would be no value in ever involving an attorney in a transaction. It's scenarios like you raised where I think it just screams out for, let's bring in an attorney to advise on this contract issue or how we draft appropriately to this circumstance based on the needs of the parties.